This is the In Focus podcast from The Hindu.
Hello and welcome listeners to another episode of the In Focus podcast. In this episode, Aaratrika Bhaumik will be talking to Alok Prasanna, co-founder of the Vidhi Center for Legal Policy, where he will be decoding Uttarakhand's Uniform Civil Code. What does this mean for minority communities? What are the broader implications of this historic decision? Many more questions like these will be simplified in this episode. So please stay tuned.
On January 27th, Uttarakhand Chief Minister Pushkar Singh Dhami officially rolled out the Uniform Civil Code, making Uttarakhand the first Indian state to implement such a law in independent India. The UCC was a key electoral promise of the BJP during the 2022 Assembly elections. Although intended to apply uniformly, the code excludes the scheduled tribes from its ambit and also retains existing legislative provisions governing the entity of the Hindu Undivided Family under the Hindu Succession Act. Proponents argue that the UCC fosters national integration and advances the cause of gender equality. However, experts have cautioned that its implementation could encroach upon the rights and distinct cultural practices of minority communities in the state. To delve deeper into the various nuances of the code and also some of the concerns it raises, we are joined today by Mr. Alok Prasanna Kumar, the co-founder of the Vidhi Center for Legal Policy. Thank you so much for your time, Mr. Kumar.
Thank you, Aaratrika. Happy to be on this discussion.
My pleasure. Before we delve into the various provisions of this particular law, Mr. Kumar, if you could start off the discussion on the extraterritorial applicability of the code. For our viewers, the code stipulates that the law will extend to residents of Uttarakhand even if they reside outside the state's territorial boundaries. So, Mr. Kumar, what is the rationale behind incorporating such a provision, and is it even constitutional?
Let me start by addressing your second question first. I don't believe it is constitutional, simply because under our constitution, states have the power to legislate for the territory of the state, right? Now, in a very limited set of circumstances, they can legislate on something which happens outside the state. You have to show that there is nexus, right? Like if I have to take one example, supposing there is a tax law and the tax law says any goods entering our state will be taxed at the borders, right? You will have to sort of pay the tax before you enter the borders. It's not like the tax has extraterritorial effect. It is just that it relates to something which is the entry of goods. It's just that you're asking them to pay before they come in. That's it. This law is very bizarre, okay, for the lack of a better word. What it says, if you see subsection 3 of section 1, it says it shall apply to all residents of Uttarakhand, even if they are not residents. Okay, that on plain reading does not make sense. We get a little bit more clarity when we see that the act actually defines who is a resident. There are 4 or 5 criteria, and these criteria have been come up with a different context. The state issues something called domicile certificates to show that you're a resident of the state. Now, this is relevant in the context of graduation, education, and things like that, where you're entitled to certain things because you're a resident of that state. And also it's kind of important for reservations and things like that, because you cannot carry your reservations with you in different parts of the country. They have just mindlessly copied that. Now, this is where grammatically now it stops making sense, because you can be a resident of Uttarakhand by legal fiction if you're eligible to get a domicile certificate. So which means you don't even have to be a resident of Uttarakhand for this law to apply to you, right? As long as you're quote unquote eligible, which means what? Your parents may be domiciled, you lived here for a few years. Those are all criteria which are set out in a completely different context that has been mindlessly imported into this, right? So effectively, law is applying to people outside the state of Uttarakhand for doing things outside the state of Uttarakhand, which have no relation to anything that is happening to Uttarakhand. Unlike in the United States, there's no concept of state citizenship. There is only one citizenship, which is citizenship of the Union of India, constitutionally. Today, the Supreme Court has clarified that there is also no such thing as domicile of states, especially in the context of constitutionally, there is only the domicile of India. In this context, for the state of Uttarakhand to apply its law extraterritorially, with something which has no nexus, right? To me, is unconstitutional, right? And that is only as so far as its extraterritorial application concerned is its application to people who may be people of Uttarakhand. Like for instance, here is where it gets absurd, right? If you have lived for a year in Uttarakhand, you're deemed a resident of Uttarakhand, even if after you move out of that place for a year. So supposing somebody who has been sort of living in Uttarakhand for 1 year, right, will be a person resident in Uttarakhand for a year when they're there, that's fine, that's understood. But when they move out, do they stop being resident of Uttarakhand? Will they now be bound by this? That's not very clear in this law. And it seems to be that even when they're not resident, they'll be deemed to be resident. So, which is why, and if the confusion is there in the minds of the viewers, it's because this act is completely confused about this. Now, let me get to the extraterritorial point about it. When it comes to personal customary laws, you carry your customary laws with you, right? If I have to use a metaphor, if you're moving from India to the US, apart from your bag and baggage, you're also carrying your Hindu law with you, right? Which means you continue to be married for the purpose of the Hindu Marriage Act when you go to the United States, right? And this is true in different parts of the country as well. You carry your personal customary law with you. Just because I've moved from one part of India to the other, I don't cease to be a Hindu for the purpose of the Hindu Marriage Act. The marriage that is carried out does not cease to have validity just because I've moved to a different part of the country. Whatever customs that I follow for the purposes of marriage, I still have to follow for the purposes of marriage in a different part of the country or even where. Now, this is encoded into the Hindu Marriage Act, which says that it will apply to also those territories which are not part of India, to wherever a Hindu goes to, right? But keep in mind, this makes sense in the context of marriage and divorce. Because those are personal laws or the customary laws you're carrying with you wherever you go. The Hindu Marriage Act just recognizes it. It is not necessarily true of the Succession Act. The Hindu Succession Act does not have a provision which says this will also apply to territories outside the territory of India. Why? Because that applies to properties. It's applying to properties and to persons. So it can't be that when I go and acquire a property in the United States, that I will come to India and ask for the Hindu Succession Act to be applied on that property in the United States. Because that property will have to be decided, the succession will have to take place in a completely different way. Question will be whether I'm even allowed to own that property. Are my successors allowed to own that property? Completely different point comes into the picture. You cannot have property in one country governed automatically by the laws of another country. I can say in my will in the United States that it should be decided in accordance with Hindu law on this. That is permitted. But automatically, the law does not apply to properties outside of India just because I happen to be Hindu, right? They've not noticed this.
Right.
Or at least I do not see anything which any explanation provided for this, why extraterritorial effect has been given, right? Is it now that every person in Uttarakhand, even if they travel out of Uttarakhand, when they acquire property outside that state, will now be governed by the Uniform Civil Code? That is not very clear. There is no reason justification
Right.
given for giving an extraterritorial effect to this law.
Right. Like you mentioned, it also does not take into account practical realities because we have so many people who move out of the state for job, for education purposes, and the state will still govern their personal relationships, will still
Yeah,
govern other aspects of their personal life. So that way, I mean, not only is it unconstitutional, but like you mentioned, there's absolutely no clarity on this. If you could
that's
also
right.
now move on to one of the contentious aspects of the law, which is the requirement for heterosexual couples to register their live-in relationships with the state. And if they are not able to do it, then they are going to have criminal sanctions imposed upon them. We'll discuss this provision in detail, but just first off, if you could tell our viewers whether this particular provision violates the right to privacy, and also can this be weaponized by the state machinery to penalize consensual relationships?
So let's get one aspect of this particular registration of live in relationships. These records are public, which means anyone can inspect, which means you're asking me to expose my private life to the public. For what purpose? For what joy? I'm getting nothing from the state. The state is not giving me legal recognition. The partner is not, either of the partners get any legal status. There are no benefits being provided. It is simply the state, as I said in a recent piece, satisfying its curiosity. Not just the state satisfying its curiosity, it's telling the whole world to come and satisfy its curiosity, right? And it's doing so on the threat of criminal punishment. Now, there is a requirement also to register marriage.
Right.
It's not new. It used to be there in Uttarakhand. There are other state legislations across the country which have mandated registration of marriages. There is a larger public policy purpose for that, which is that the woman gets a certificate which shows that she is married, allows her to easily access certain rights and liabilities. But even then, it's not necessarily conclusive proof in a lot of instances. For better or worse, that's at least some public policy justification given for this. As opposed to registering a marriage, if you do not register a live-in relationship, you're going to be 3 months imprisonment along with a fine, right? What harm are you causing to anyone?
Right.
Right? There's an assumption that every live-in relationship, if it is not registered, is some sort of a crime against the country or the society or the state. This is a direct infringement of two aspects of the right to privacy. When the Supreme Court was delivered its 9-judge bench decision in case Prasanna versus Union of India, this is in the context of Aadhaar, they have clarified the scope of the right to privacy. The scope of the right to privacy includes decisional autonomy, bodily autonomy, and informational privacy. I should not be asked to reveal something that is private to me unless there is good justification for it. And there should be a close nexus between what you're asking me to reveal and what is the state purpose in this particular prospect. The state purpose, as best as I can make it out, seems to be, oh, there are lots of crimes committed between, people in live-in relationships. I mean, that happens on a day-to-day basis. It's not as if tomorrow I have to make my bank accounts public. I have to show everyone in the country how much money I have so that no theft takes place. We have seen the instances of digital arrests and so on, which allow for scams. This doesn't mean that now I have to just make my money public. I have to let the entire society monitor my proceedings for 24 hours a day just so that I'm not caught up in a digital arrest, right? So there's no proportionality also here. Keep in mind, let's not forget the societal context. People in India are literally killed on a day-to-day basis for entering into live-in relationships or just basic relationships for someone of the unacceptable caste or the unacceptable religion. All the state is basically now saying is we don't care. We're not going to stop those kinds of killings, but we're okay. But we are so concerned about live-in partners killing each other that we will force you to reveal yourself and expose yourself to greater threat. Right? So in a way, this is the state doing the reverse of the RTI Act. Now saying, give all your information to me, make it public. I want everyone to know who you are, what your personal life is, right? So that they can do whatever they want to you. And if you don't do any of this, I will impose criminal penalty on you. You cannot think of a more anti-liberty, anti-privacy, anti-basic human dignity legislation than this. Right? It's a bit like saying everyone walk around with your caste certificate so that we know caste atrocities happen, but walk around with your caste written on your forehead so that we can take action if something bad happens against you. Right? That's a complete violation of human dignity. So I think that is really what this law is doing.
Right. Another aspect of this particular provision, which is of course quite absurd, is that if you're below 21 years of age, then your parents will also have to be in the know-how. The concerned registrar will have the liberty to inform your parents, and that is against the law of the land, where you attain majority at the age of 18. You can marry at the age of 18, but you cannot be in a live-in relationship without the consent of your parents until you are 21 years of age.
Yeah, I mean, in a sense, again, even marriage, it depends. Different laws have different provisions on that front. But let me make this clear. The Supreme Court has said time and time again, right? Not the Supreme Court, every High Court has said this again and again. Once you're a major, decision on whom you want to live with, whom you want to be in a relationship is purely yours. No one can interfere with that relation. Here now the state is saying that I will ensure someone interferes in your relation. I don't believe you are a major enough to take this decision. I will make sure that somebody else is informed about this so that they can try and dissuade you or do whatever else, right? And again, this is not a hypothetical situation where maybe people will have one view, maybe people will not have another view. We have seen the instances of violence against young couples in this country. Forget violence, it is state-sanctioned violence also. We see this in the fact that criminal procedure is used to stop couples from eloping. Kidnapping cases filed against the man. If not kidnapping, sexual assault cases, POXO cases are also filed, right? to basically make sure that person is arrested for these kinds of intercaste, interreligious, or any kind of quote unquote prohibited relationships. Now the state is saying we are on the side of the families to try and stop such relationships. This is the signal that the Uniform Civil Code is sending out. That all this talk of, oh, we want to try and prevent violence against partners is nonsense. There's the Domestic Violence Act, which recognizes that violence against live-in partners will also be accounted for, that there will be necessary mechanisms, there are necessary procedures under that act which can be invoked for that. That is completely ignored, right? There
Right.
is just using one or two instances. It's somehow a bad thing if a Muslim man in a interreligious relationship with a Hindu woman commits violence. That is extremely bad. But if a woman is killed and the man is killed by the family of the woman, irrespective of religion, because because they're in a prohibited relationship, that the state doesn't care about. That the police will see when they will see. So this sort of tells you what the approach of the state is. That it wants to clamp down on these kinds of relationships. And
Right.
it wants to use the law to prohibit these.
Since you brought up the Protection of Women from Domestic Violence Act, which is the existing law on governing domestic violence cases, is there clarity on how this particular provision would intersect with such a law? Because the Domestic Violence Act does recognize relationships in the nature of marriage. Women are given adequate protection under it. Now, what happens in a scenario where I'm in a live-in relationship but I do not register it? Will I still be entitled to the guarantees under the Domestic Violence Act? Is there any clarity on this front?
From my reading of it, the two are completely separate. That registration in one is not necessary for you to get the benefit of the other. Keep in mind also that the registration requirement comes into the picture 3 months after you're in such a relationship, right? So rather, 1 month after you enter into such a relationship. There's nothing per se linking, and they cannot say that such a right will not be recognized. But that's not how law works in India. We know that at the ground level, somebody will say, show us proof of your quote unquote live in relationship before we take any action. Forcing people to register to ensure that they get protection under the domestic violence law. None of this will be mandated in the law. It is just how the practice will occur, and this is how the message gets sent out to the larger system, which is all your officers, all your police, all of that, right? And again, the law will have unintended consequences. Maybe they don't even intend for this to happen, but this is what will happen. The police will say, unless you get a certificate, I can't be bothered to do this. And what are you going to do when the police or the authorities refuse to act against this thing on? Otherwise, you were supposed to act on a simple complaint. Now they might say, no, there's a registration requirement. And if you haven't registered, too bad, I can't protect you from domestic violence. Again, none of this is mandated by the law to say don't do it. But this is how the message will be received by the system. This is how the person in the police station will react. Right? And we have seen this happen with a lot of other laws. We have seen
Right.
it happen specifically in the context of POXO, where even when parents are perfectly okay with a consensual relationship featuring a minor, say about the age of 16 or 17, police have put pressure on them to say, make a complaint. This is illegal. If you don't report, I will throw you in jail. Again, no one is harmed here. No one has but the system has gone out that any sex that a minor has under the age of 18 is per se criminal, and everyone concerned should be prosecuted. So that is my fear here. If we follow the mandate of the Domestic Violence Act, state can't introduce a barrier to say no, you have to have it registered before you seek any protection. Right? Likewise, simply because there's a requirement to register a marriage, even in a marriage situation, nobody can, in a domestic violence act, nobody can say, get your marriage certificate before I take any action. But the rhetoric being created around it, the signaling being created around this law, will essentially deter somebody to say, I don't want to take any action because I don't want to abet a criminal offense. What is a criminal offense? Being in a living relationship without having registered.
Since we're talking about unintended consequences and how this particular law can also disproportionately affect couples who are in interfaith or intercaste relationships, let's talk a little about the notice and objection regime, which we see here, which we've also seen in other laws such as the Special Marriage Act. Now, the Supreme Court declined to address this issue in the marriage equality case. Do you think this law could finally prompt the court to decide the constitutionality of such a regime?
This is a tough one to answer. I'll tell you why. Because the origin of this provision was not to prevent elopement or anything like that. The origin of this was to prevent someone from getting a second marriage properly registered with the state. Because keep in mind the context for all of this. The context for all of this is the state in India hasn't really interfered in, or rather, hasn't even legislated in questions of marriage and divorce and so on till the 20th century. Right? And that was also to stop harmful practices. It's not as if the state said marriage is only this if you do this, 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 and this. And always it was left to society to take care of these things. We will just enforce whatever society decides on this point. It's only once there was a push by social reformers in the 20th century that we started seeing legislation. And it was only in the mid 20th century we started getting codified in certain laws. Right? So, Special Marriage Act, which was again applied only to a minuscule section of society before the 50s, right? Uh, the requirement for notice was not about stopping interreligious marriages. It was to make sure that if somebody had a marriage, like if two Hindus got married and the one partner ran away to get married under the Special Marriage Act, under some other legislation, that you don't create two victims in the process, right? You
Right.
avoid this kind of complication that actually this person has been married to me well legitimately under the Hindu marriage this thing, so therefore I object to it. So that was the intent of this, because it also is a law which prohibits bigamy in that context. This is being misused. Now, misuse of a provision does not necessarily make it unconstitutional, because there is a legitimate purpose for it also. I can understand if there is a provision where there's absolutely no legitimate purpose. I would think there is absolutely no legitimate purpose of making records of live-in relationship public. There is absolutely none. What is being stated has no relation to what is actually being proposed. But there is a legitimate purpose to saying public notice that this person proposes to get married under a Special Marriage Act. Let us know if there are any objections to it. All right. That is to protect maybe women, maybe also men at some point of time, who may have been to ensure that they are not suddenly left remediless, that somebody hasn't gotten married a second time without telling them about the first marriage, which happens in our country. It's not a completely unimaginable situation. So you can't say possibility of misuse will mean it has to become unconstitutional. All right. So
We,
so so to that extent, I think again, simply striking it down does not address the problem. It may create a different kind of problem. You
you
need
believe
to
there should be
have
more safeguards instead of just striking it down.
it again. This is something which the law should be amended to sort of say this is the list of objections that you can make. The list of objections has to be that you are related to this person, that under the terms of the act that this will be a void or avoidable marriage, and that they have concealed something. It cannot be that any Tom, Dick, and Harry can come forth and say that no, I want to be able to object to this, or it should be made public in a manner which will ensure that anybody who objects also has to pay a fine to object. If their
Right.
objection is invalid, they should lose the money for it, or not a fine, or some sort of a fee or something. You can, and these are all not something which court can craft. These are all remedies that needs to be there statutorily, right? So it cannot. I honestly don't think the court, by simply striking it down, they may protect certain kind of set of couples, but they may be exposing someone else to a different kind of problem, which this law is intended to protect them against. So I don't think striking down constitutionally is the approach. Because if you apply the same test that I mentioned earlier in terms of what do you call informational privacy,
Right.
right? It's a 15-day notice, which is a valid requirement. It's a proportionate requirement. It's not as if you're required to inform the whole world. You put up the notice at the registrar, right, for a period of 15 days, inviting objections. And those objections can relate to something which is legitimate, which is that this person is already married, this person is not a major, this person has deceived someone else, therefore this marriage should not go ahead, right? I mean, if you think back to and the origin of it, you could also say in the context of Christianity, where if you've seen the vows, when the priest sort of says that if any person who may objection to this union may speak now or forever hold their silence, right? That's what the state is sort of doing in a slightly different way. So that's not
Right.
illegitimate per se. So I would say it meets that test. Even if you apply the test later on in the Puttaswamy case, it meets that test. There is legitimate state interest in preventing harm to someone else. It's a proportionate measure which says just put it out in the registrar's office and so on. It's a different matter. People have found a way to misuse that also. Now, striking down for constitutionality will not prevent it may prevent one sort of misuse, but it doesn't mean that other people are also protected.
Right. The code also treats children born in live in relationships as legitimate, and a woman can also claim maintenance in case she is deserted by her live in partner. Do you believe that these are undoubtedly positive reforms that the code has come up with?
Possibly, but my question is that in what context, right? In the sense that the law does not necessarily say, and this is something which, unless you show that there was no marriage whatsoever, there are existing tests to show legitimacy of a child and so on and so forth. In fact, courts have tried to avoid using terms like legitimacy and so on because they feel that this kind of is an stigma on the child as opposed to what the term is supposed to mean. In some senses, it perhaps addresses it, but it doesn't change the fact that it is still seen as distinct, right? Now, in terms of succession of property, we don't know. We don't know what will be the implication of this. And this is where the question of quote unquote legitimacy comes into the picture, right? Is the child entitled to inherit the property? That is not fully clear. Will the child be treated, if for instance, a person is married and without marrying enters into a quote unquote live in relationship, supposing they follow all the other requirements of law, will the child be treated at par with the child from the other marriage? We don't know. A lot of that is there to be clarified. And in some sense, maintenance is something which could be kind of sought on a lot of bases, right? Now, it isn't as if there is automatic right to maintenance. You have to show abandonment. You still have to go to court. All that process is still there. And again, court has sort of evolved tests over the years. It's not as if for 180 years, everybody saw Section 125 of the CRPC and said, no, 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 you have to be absolutely married to every last T until you can claim maintenance for the purposes of the Code of Criminal Procedure, right? You could not have claimed it under the Hindu Marriage Act for that, or the Hindu Adoption and Maintenance Act for that purpose. But there have been tests that if you have been living like husband and wife, the provision was there to prevent destitution. So, in some senses, there have been tests which have been laid on from this front. So, even that was somewhat judicially taken care of without necessarily having to impose these requirements.
Right. So we'll basically have to see how it plays out, even when it comes to maintenance for women in live in relationships who have been deserted. The other question that is very important to discuss is the fact that the UCC is absolutely silent when it comes to rights for the queer community. Now, why that is important is because we have seen the Supreme Court in the marriage equality case affirm that it is the legislature's prerogative to recognize rights for the queer community. So, do you think this is a missed opportunity in that sense?
Yeah, absolutely. And I think this is something where even we at Vidhi, we have sort of come up with this draft code, which tries to account for the rights of the queer communities and so on. The fact of the matter is that questions of what is marriage, what is divorce, right? There are different definitions of these. There is no one universal, all-encompassing idea of what is marriage and what is divorce. Some countries recognize polygamy, some countries don't recognize polygamy, right? For the law, for the purposes of the law as such, if a country recognizes it, it is legal, right? This is what the queer critique of family law has done. It has made us question what are these ideas of family. It has said there is no one definition of family, that it cannot just be one man and one woman, right? And we see that debate happening in different parts of the world. If you're now going to say uniform, right? And even that you have made exceptions for scheduled tribe communities, right? Fine.
Hmm.
All right. There is a reason to do that because the Hindu law does not apply to them. So, in that sense, they're allowed to retain their customs. But here's the deeper question. If it is about reform as opposed to imposing uniformity, why not open up these questions also? Right? Why not open up questions as to whether marriage should just be between one man and one woman? Right? Why not say that, okay, you want monogamy, fine, that's all right, but does it necessarily have to be between one man and one woman? What about the fact that, people are perfectly capable of having these relationships? And even you as a state have acknowledged that, yes, some people may not want to get married, but want to live together because that's the core of all of this. Because the thing is, let's face it, our societal ideas of what marriage were is more like a property transaction. You give the daughter in marriage. you take the daughter in marriage. It was never about two people finding love and living together. That's a very modern concept, and that's what our laws are trying to find their ways to update themselves. So why not also include the fact that two people of the same gender could also find the same kind of love and may want to live, may want to have this commitment, may want to have this kind of lifestyle. So I think this is a hugely missed opportunity. It was an opportunity to sort of, push family law reform, but there is no reform here, right? There's very little by way of reform. It is mostly force, right? It is we want to show that we want to impose these
Right.
obligations on these people, and we can do it now. Is it good for anyone? Nobody has answered any question.
Right. Right. Another criticism of this law is that it disproportionately affects Islamic personal law practices, even progressive practices, to say, for example, the payment of meher, which provides financial security to the wife. While, as I already mentioned, while I was, beginning the discussion, that the code is completely silent on gender-based disparities within the Hindu Undivided Family entity under the Hindu Succession Act. So, do you think this is a fair criticism to speak?
So let's just keep two things just clarify. The Hindu undivided family as a concept comes from tax law. The Hindu Succession Act talks about the joint family. Now, Hindu Succession Act was amended in 2005 to bring some sort of parity between men and women in the context of Hindu succession, right? And this is only as far as coparcenary property, which is the common property owned by the joint family is concerned. Right now, this is something which states have been making the reforms in over the last several years. Now, in the context of Islamic law, also, there is supposed to be a part of the property of the person who owns it which cannot be willed away. Right now, in the context of Hindu law, you can will away the entire property and deprive your daughters of a share in the property. Right, and this is for non-coercive property. In Islamic law, that was not possible. There is an almost mathematical way of dividing up property. Now, the true effect of this might be, and again, there is also another aspect of it which not too many people have looked at, which is that the Shariat Act did not apply to agricultural property. Now, again, I don't know the specific dynamics of Islamic communities in Uttarakhand. I don't think there are more than 1 or 2% of the population, so some of this might not necessarily be applicable. But the fact is that this something like this might result in women being deprived, Muslim women being deprived of their property because now their fathers have the right to completely cut them out and leave the entire property to their brothers. Whereas under Islamic law, there was only a certain limit to which you could will away your property. 1/3 had to be divided in a particular way. Now, how much this happened to what extent is debatable, that is subject to research. But there were certain rights. Now, coming to the marriage aspect of it as well, Islamic law is perhaps the first which kind of recognized marriage as a contract, which is why the terms used in Islamic law are closer to the Contract Act. And even the procedure of marriage is actually closer to contract. There is an offer, there is an acceptance, and there is consideration. That is what meher is supposed to be, right? It is consideration in some way that is for the woman to have as use as per her desire. Even ending a marriage, divorce is actually a much more Christian concept where there was no concept of a marriage being a contract. It was a sacrament. If it's a contract, termination of a contract is the most natural thing everyone has done, which is why the process of ending a marriage is fairly straightforward in Islamic law. Right? Now, of course, you can say that has led to unfortunate consequences for women, so certain kinds of ending a marriage should not be allowed. And even then, you have, as women are entitled to remarry. There is no prohibition on remarriage. There is a certain waiting period. You have to provide for women in that waiting period. So there is a certain context in which this particular legal regime was evolved, right? And there are certain problems with it which need to be addressed, but on its own terms. Now you have said we'll throw out all of this. We will treat everyone in the same way. But that same way is completely confused because this law has no standard definition of what makes for a valid marriage. In Hindu law, a valid marriage is when you do walk the saptapadi and you tie the tali. In Christian marriage, it is when both parties say I do in a particular context. In Islamic law, it is kabul hai, that kind of things, right? This says, follow whatever ritual. It seems to think this ritual is this empty process without realizing that's what makes a marriage from a not marriage, right? So, in some sense, this law may actually have the perverse effect of making it unclear for everyone whether a marriage has been validly entered into or not, correct, between two parties. And even the certificate, keep in mind, is not conclusive proof that a marriage has taken place. I can't just register, two people just can't register a marriage without having actually gotten married in the first place. And if you haven't, if the law doesn't tell us what constitutes a proper marriage, right, then it is open to interpretation whether this is valid marriage or not. Can a Hindu and can two Hindus follow Islamic rites and say, yeah, we are married? That's right. And to that extent, I think this doesn't provide any certainty on that front. There is a vague provision. It says, yeah, you can get married however you want to, but register it. But what do you mean, however you want to? There is a way that Muslims are supposed to marry that is recognized under Islamic law. There's a way that Hindus are supposed to marry that is recognized under Hindu law. Who say all these distinctions are now gone? Is that seriously what they're saying? Because if they want to do that, they can do it. But I don't think they really understood the implication of saying what they have said.
That brings us to the last question for the evening. Prominent Muslim organizations have expressed their intent to challenge this law in the High Court as well as the Supreme Court. Uh, in your view, do you think this is going to be a successful challenge? And more importantly, which particular provisions of the law do you think are most susceptible to constitutional scrutiny?
See, I think you have to sort of be able to distinguish between what kinds of challenge, right? Now, merely because you practice a certain form of personal customary law does not make it an essential part of your religion. Now, this is what needs to be clarified when they say that they're challenging it. Challenging it on what basis? If you're saying that your essential part of your religion is to follow your Islamic religious practice, I think that's a non-starter. That's a non-starter because no one can say that my religion requires me to follow only exactly this process in this particular way and nothing else. And when it comes to personal laws, not talking about how you worship God, right? I think that's a non-starter because the moment you look at Islamic law across the world, you see the diversity of it. You will see that it is even if you were to make no, all Muslims follow this, you can't make the claim that all Muslims do this. You think things have changed around the world. There are different processes, there are different procedures. Some kinds of divorce are accepted, some kinds of not. Unless you're saying, and this is where the argument has to become absurdity, that the Sharia Act is so essential that a law passed during British times which recognizes the Sharia practice in a certain way is so essential that nobody can interfere with it. That's an absurd argument because there have been lots of changes made over the years. You have never challenged them as being unconstitutional, or rather, there have been lots of reform movements, such as, for instance, the Protection of Women's Rights on Divorce Act, which was the way to overturn Shah Bano, but actually gave greater rights to Muslim women. The more recent banning of the Triple Talaq Act and so on, the Triple Talaq. So my point is that claiming that there is something essential religious fails on the first step because, like I just said, marriage in the Islamic context is pure contract, right?
Right.
Now, you could, and it'll be even harder to make any argument from religion because nowhere in Article 25 does it say that everything about a religion is immediately protected, right? You have to essentially show what is the essential religious practice that has been granted for. And the fact at the end of the day is the Constitution also provides for a uniform civil code. It in the directive principles of state policy, where it says that we would ideally like at some point of time for all religions to follow the same family law, which is fair, right? We see the debate which took place in the Constituent Assembly. Nobody said it is a per se bad idea. They said today it's not a good idea. Maybe we're in a different position in 70 years. But like I said, there is a very different way to attack such kinds of laws, which is invasion on the right to privacy, right? Which I think, especially the driven relationship aspect of it, should be challenged and should be something. I mean, there may be more smaller challenges here and there in the context of arbitrariness and the fact that it doesn't provide certainty. And like I said, extraterritoriality. That's a straightforward question of now. You may read it to say it applies only to people who are living within the state of Uttarakhand, but that creates new problems. As a tourist, the moment I walk into the state of Uttarakhand, am I going to be covered by this act? Right? I'm not so sure about that. And that's the problem with states trying to pass a uniform civil code. This is what has not been fully understood, right? Does that mean the moment I walk into Uttarakhand, unless I have a marriage certificate, I'll have to pay 10,000 rupees as a fine? Right? Again, this is assuming that the extraterritoriality requirement is struck down, right? And so the question is, who does it apply to then? Every person in the state of resident? No, it has to be an even smaller subset of every person living in the state of Uttarakhand. What happens when they leave the state of Uttarakhand? Can somebody who's living in Uttarakhand go get married in, say, Bangalore, right, in accordance with the Hindu Marriage Act, and come back to live? Is there then the requirement? Can two people living in Uttarakhand who have an address in Uttarakhand go have a living relationship in Delhi, and now are they required to register in Uttarakhand that they're living in Delhi in this way? See, these are all kinds of issues which come up that even when you sort of strike down parts of it for constitutionality, I think raises the question. And finally, the larger point is always there, which is uniformity is not the fundamental value which the Constitution wants out of a uniform civil code. That when the
Right.
Constitution framers were saying uniform, they didn't mean make it uniformly oppressive for everyone. It is not a uniform civil code if you say no marriage is recognized anymore. No women have no rights under marriage. All women, irrespective of religion, will have no right to maintenance. Children will have no right to inherit their property. That's not a uniform civil code. There are supposed to be certain other values which a uniform civil code is supposed to be informed by. So again, these are the other values which perhaps maybe need to be explored, interrogated when provisions of this law is challenged. But
Right.
I
We'll have to
suppose
see what the grounds of challenge are.
we'll have
Like,
to see specifically. But again, like I said, it depends on the kinds of provisions being challenged and from what perspective they're being challenged.
right, right. I mean, we saw that also, how you attack a certain law or practice during the entire hijab verdict as well. But you believe
Yeah,
that it's going to be a more successful challenge if, let's say, we say it's an Article 21 violation, give
yeah,
precedence to an Article 21 violation.
yeah. I
Thank you
think that's
so
a
much.
great example because in the hijab case, perhaps the most compelling argument to Justice Sudhanshu Dhulia has pointed out in his judgment is education. He's
Right,
saying the best argument against the hijab ban is under Article 21A because it is preventing the right to access to the right to education. So therefore, it should not be permitted. It's not about religion. It is not even about individual personal choice, right? Maybe it might be to some extent, but it is about religion. So it's not about religion. So in that sense, it depends on the angle and the approach and which articles are being in.
right. Thank you so much, Mr. Kumar. Thank you for your time. This has been a very insightful discussion.
In Focus will be back soon with analysis of the biggest news issues. In the meantime, you can find our podcast on Spotify, Apple Podcasts, Stitcher, and other platforms. Just search for In Focus by The Hindu. We'll see you soon.